If you have ever used an LLC or a trust to hold real estate for privacy protection, there's a new federal law in 2026 you need to know about because it changes how those transactions work. I'm Mitch Green, a partner of Kramer Green. I work with clients who own real estate and want to protect it properly. And today, I'm going to walk you through the new FinCEN reporting rules and what they mean for you if you own property or plan to transfer it. Let me explain this the same way I would if you came into my office. A lot of clients I speak with use LLCs or trusts to hold real estate. They do it for good reasons: privacy, liability protection, and long-term planning. Beginning on March 1, 2026, the federal government is requiring more transparency for certain residential real estate transactions. Specifically, this applies to non-finance transfers of residential property to entities or trusts. So what does that actually mean in plain terms? If you're transferring property without a loan and the buyer is an LLC or a trust, that transaction may now have to be reported. The key point I want you to understand is this: the rule is not stopping you from using LLCs or trusts. You can still absolutely use those structures, but it does mean those transactions are no longer private as they once were. The reporting requirement is focused on transparency. The professionals involved in the closing, such as attorneys, title companies, or settlement agents, are responsible for filing what is called a real estate report. That report includes information about the property, the transaction, and most important, the beneficial owners of the entity or the trust. So if you own an LLC that is buying property, there may now be a requirement to disclose who actually owns or controls the LLC. Now, I want to address a concern I hear right away. Clients ask me, does that mean my information is going to be public? The answer is no. These reports are not publicly available. They're maintained in a secure federal database and are not accessible through public records requests. But it does mean there is now government visibility into transactions that previously may not have required that level of disclosure. Another important point is timing. The report has to be filed shortly after the closing. So if you're involved in one of these transactions, preparation becomes critical. I tell clients this all the time: do not wait until the closing table to figure this out. If you have an LLC with multiple members, or a layered ownership, or a trust with several parties involved, you're going to need documentation ready: ownership charts, trust documents, and identification information. All that needs to be organized ahead of time to avoid delays. I have already had conversations with clients who assumed their existing setup would continue to function the same way, and in some cases, it needed to be adjusted. Not because the strategy no longer works, but because the rules around the reporting have changed. So, what should you take away from all of this? Structures still work. LLCs and trusts are still valid, effective tools. But now the process requires more planning and more transparency. And the earlier you address that, the smoother everything will be. I'm Mitch Green with Kramer Green. If you're planning a real estate transfer and want to review your current structure, reach out to us and let's make sure everything is set up the right way moving forward.